I would like to discuss with you physical child abuse. Nothing is more heart-wrenching than photographs of a young child who has been severely physically abused. They most often show large bruises, burns, welts, or scalding that brings tears and the urge to stop this type of torture, even to the most hardened of investigators. Such disturbing photographs are also shown to legislators to help pass new laws to secure additional funding for social agencies. When the public hears of physical child abuse, these are the very images that come to mind. In actuality, there are very few allegations of this type of serious abuse. In those rare cases of severe physical abuse, the physical evidence is often overwhelming and proves that physical child abuse has occurred. The only time that a false allegation might arise is if the true perpetrator falsely accuses someone to avoid punishment. So where are all the allegations of physical child abuse coming from? For centuries in Judeo-Christian communities, parents have used physical discipline, or corporal punishment, as a means of teaching their children right from wrong. The Bible refers to such physical discipline in its warning, "Spare the rod and spoil the child." However, shortly before World War II, this means of molding a child's moral character was challenged by a well-known pediatrician, Benjamin Spock. He proposed positive reinforcement and non-physical discipline as the more enlightened method of child rearing. Spock's methods were popular in more liberal circles and became the philosophical underpinning of social workers, child therapists, and child advocates. It still remains today as the foundation of training done by state agencies. More conservative parents, however, particularly those with fundamental religious beliefs, have long opposed Spock's ideas. That is why the fierce conflict between these two perspectives of handling children is still not resolved in the courts. In response to the horrors of physical child abuse, many state legislators wrestled with how to define what constitutes such abuse in the early 1990s. Representatives were highly lobbied by both social workers who wanted corporal punishment outlawed and various Judeo-Christian groups who believed that it was their religious right to use corporal punishment. The end result was ambiguous statutes. Is it physical abuse if you spank your child on the back of the leg rather than on the bottom? What age is appropriate for discipline? How does one define serious physical injury? Can a red spot caused by hand spanking be a serious physical injury? These are the terms found in many state statutes, but none are properly defined. Therefore, the manner in which these statutes are being interpreted depends upon the child-rearing perspective of the people enforcing them. For example, we have found that Child Protective Services officials in many states generally interpret the use of any instrument on the child as physical abuse. For decades, however, mothers spanked their children with a wooden spoon in order that the mother's hand was not associated with inflicting pain. Does the spoon used with the same force as one might use a hand to spank a child constitute an instrument of abuse? In many states, Child Protective Services workers have taken children away from their parents for such disciplinary conduct. Our office has counseled many Judeo-Christian oriented parents who have raised their children with love tempered with physical discipline, only to be terrified by allegations made by Child Protective Services or the police against them for child abuse. Since Child Protective Services as a group is against corporal punishment in any form, they are very liberal in interpreting corporal punishment as child abuse. They can use their power to seize children and can request the police to make an arrest for child abuse. The police and prosecutors are not so uniform in their interpretation. Each officer, each department, and each DA's office has a different view of what is legal corporal punishment and what is not. However, police and prosecutors tend to ignore the perspective of some Judeo-Christian oriented families who feel it is their right to use corporal punishment for discipline. The freedom given to Child Protective Services workers, police officers, and prosecutors in defining corporal punishment is what most often leads to false allegations of physical abuse. Their freedom turns into unchecked power when combined with the unlimited resources of the DA's office and an often misinformed or biased staff and judicial system that relies upon information from people in the employment of the state. Even though the ultimate authority, the jury, will decide what is reasonable treatment of a child, it is unfair to expect families to bear the costs and trauma of a jury trial in order to establish that they were doing simply reasonable discipline. Many state laws, as they currently stand, make it possible for agents of the state to control parents' actions, even if the parents are acting in the best interests of their children. And while Judeo-Christian groups can influence what laws are written and passed, they have little power to influence how social workers or officers of the legal system interpret child abuse standards. That may mean arrest, jail, and a seizure of your children, should you believe that you have the right to physically punish your child in order to reinforce moral training and education. As we have said, the training that most social workers, the police, and officers in the legal system receive predisposes them to believe that signs of physical contact with a child, like bruising or a red mark, can be a sign of child abuse. This is because of their concept of corporal punishment. The odds are even higher that parents will face criminal charges of physical abuse should their child be very young, nonverbal, or display a severe bruise, injury, or fracture that cannot be accounted for by a parent. Unfortunately, our office knows this all too well from experience. One of our cases involved a child who was being carried in her mother's arms as she walked through the airport. The mother tripped and fell to the floor on top of the child. The little girl hit her head and began crying. The mother believed that the child was uninjured when the child stopped crying and Mom continued home. The mother then left the child with the father to babysit her. Several hours later, the child became seriously ill, and after being rushed to the hospital, X-rays revealed a fractured skull and a subdural hematoma. The father was immediately arrested for physical child abuse, handcuffed, and taken off to jail. He faced a maximum of 8 years in prison because the radiologist, a self-proclaimed child abuse expert, reported that the force of such an injury was either a fall from a third-story window or by swinging the child by her feet and smashing her head against the wall. During courtroom testimony and cross-examination, the radiologist admitted having no scientific basis for her opinion. She could not name one controlled scientific study that supported her claim that such force was as she described was necessary to cause the child's injuries. Furthermore, she admitted that she had never personally witnessed a child injury by a 3-story fall or being swung by the feet and having the child's head smashed against the wall. In summary, she had no scientific studies and no personal knowledge upon which to base these outrageous conclusions. Why was there a lack of science in her testimony? First of all, because she was trained to be a child advocate and had no other experience, scientific or personal, in the field. Her first response was to claim child abuse. Secondly, studying the force required to create fractures in children entails human subjects, an unthinkable type of study in our society. Our research, however, did find studies based upon deceased animals whose bones had the same dimensions as those of children. However, the child abuse expert called by the state rejected the animal studies on the grounds that there were no comparison studies between animal bones versus human bones. Therefore, the validity of the controlled university research was brought into question. But we didn't stop there. Our researchers also discovered actual human studies done in Europe. After we translated them from German into English, we learned that in Germany, several studies were conducted on children who had recently died. One study focused specifically on measuring the force necessary to break limbs. Another on the force needed to fracture the skull. These studies showed that the kind of damage sustained by our client's child could be caused by a fall of only 3 feet onto a hard floor like that found in an airport. That was approximately the height of the fall the child suffered while being held in her mother's arms, and then having her mother fall on top of her when the mother tripped.